Roger, LNG Ltd and Taleveras Petroleum Trading DMCC.
Yes, Mr. Hussain.
My Lord, as Lordship knows, I act for the appellant and LNG, along with Mr. Grimm, Mr. Kitchener KC, Ms. Pelling KC, and Mr. Gardner act for the respondent Taleveras. This is NLNG's appeal from the order of HHJ Pelling KC on 9th of August 2024, in which he dismissed NLNG's claim and granted permission to Taleveras to enforce certain paragraphs of the final award in the spot CN arbitration insofar as they apply to the default proceedings, and permission to appeal was granted by the trial judge. As your Lordships know, there are two relatively short issues on appeal, albeit I anticipate I will be taking the morning to set them out. They are first the construction issue, namely whether what has been denoted the endorsement requirement in paragraph 607 of the Dispot CN award is an order, or put otherwise, a dispositive part. And secondly, the jurisdiction issue, namely whether the VTOL tribunal had the jurisdiction to give the endorsement, pursuant to the endorsement requirement, by an additional award after it had rendered its final award and become functus officio. And for the purposes of this appeal, I need to succeed in persuading your Lordships on both of those points. Lords, there are two points that no longer rise. First, privacy, and secondly, a side issue relating to the Glencore arbitration. We wrote last week about both. As regards privacy, we don't make any application. I'll therefore be referring to the parties by name. I'm sure your Lordships have it, but NLNG is AZ, Taleveras is BY, VTOL is CX, Glencore is DW.
There's no judgment with the parties' names in.
There is not, my Lord. It shouldn't interfere with the submissions because there's very little that's redacted that is relevant apart from the name of the parties. I'll be making my submissions by reference to Core 5, which is where the approved judgment appears.
Just to be clear, so the judge didn't produce a non-anonymised judgment.
I couldn't find it in the court bundle. I don't believe there is one.
Did he make an order for anonymity?
He did. Oh, yes.
We got that.
He certainly did produce an unanonymised version
Yes.
of the judgment.
Initially, yes. And
Yeah, I'm going to make my submissions. Well, I'll try and change it by reference to the document in tab 7 of the core bundle. But I assume that it's accepted now that the anonymisation that was ordered by the judge should be regarded, and we'll might have to work it out by reference to the order, but that privacy element of the original order need not be maintained. I assume that's common ground.
yes.
We don't usually regard first instance orders as to anonymity as binding the court.
No, of course, but it's more the anonymisation of the original judgment.
Yes. What's slightly odd is now, when we do not have anonymisation, we haven't got the judge's unredacted decision.
Yes.
Can we have it?
I'm not aware that there is an approved unredacted version, and there certainly isn't one in the core bundle. So, with apologies, I'll be referring to.
No. I mean, you must refer to the ones in the bundle. But I would if there is one, I'd quite like to have it. That's all.
I'm sure there is one.
Yes,
we'll get it for you.
I would be sure there was one as well.
And just picking up the second point in relation to Glencore, at the time of the judgment, the Glencore arbitration in respect of 6 spot CN cargoes was ongoing. There had been a substantive hearing. There hadn't been a final award. Since then, there has been a final award. That award included the endorsement requirement fulfilled by the Glencore tribunal. the award's been paid, no issues arise in relation to its validity. My lords, in terms of documents, there are relatively few documents we're going to need to go to. Besides the skeleton arguments, as I say, the judgment at Core 5, the Spot CN award at Supplemental 14, the Spot CN interpretation decision at Supplemental 19, the VTOL additional award at Supplemental 24, and I'll also show your lordships the Taleveras draft order in the Spot CN arbitration, which is referred to in the Spot CN award, which you'll find at Sup 90. But I'll take your lordships to those when we get there.
Yeah.
I'll also be showing you some authorities on both the construction issue and the jurisdiction issue. Those are relatively short, and ultimately most of the points that your lordships are being asked to consider are going to be resolved as a matter of principle, because there is a lack of authority, at least in relation to the jurisdiction issue. In terms of timing, I'm going to spend just over half my time dealing with the construction issue and then deal with the jurisdiction issue. Finally, could I ask whether your lordships are working from hard copy or PDF?
I'm working from hard copy.
I'm electronic.
It's a mixture.
In that case, I need to make a further apology, which is that the authorities bundle is a few pages out in the PDF.
Nearly always is.
And
one of
it
the
is
delights.
because some A and B numbering was added in late, and it wasn't. We didn't want to disrupt the skeleton referencing. So once you get past page 9, I believe it's +3 in the PDF. But I'll give the hard copy.
Well, the typical problem is, and we've got it here, is that people start numbering, and then they haven't got. Typically, they start numbering with the first page of the first authority, which creates.
Yes, I'm
that
happy to
problem-
say
we don't have
that
that
mistake has not been made, but a different
No, well, that's understandable. Thank you.
issues.
So it's about 4 pages out.
3, I believe. So, my lord, I wasn't going to rehearse the underlying fact to the arbitration. I'm sure your lordships have that. Just in terms of the construction issue, so that there are disputes between the parties about what the authorities demonstrate about the correct approach. There are disputes about whether some of the authorities we rely on are applicable to the construction issue that your lordships have. There are some further authorities Taleveras relies on, which were also considered by the judge, Bank Malat in particular. In our submission, the principles that we say apply ought really to be uncontroversial. They are simply this: the whole of the award should be considered when working out what the dispositive parts are. Form has a role, but the emphasis should be on substance over form. The question should be objective, based on what a reasonable recipient of the award would have understood had been ordered, and the court should adopt a reasonable and commercial approach to interpretation. It should not be looking to pick holes in an award. It should be approaching it with the expectation that it is a coherent award. And to the extent that authority is needed for that approach, one finds it in the general guidance given in the ZCCM case, which I'll come to, the approach taken in Cadogan and French State in different but analogous contexts. So with that, my lord, if we can go to the, I'll take your lordships through the judgment.
Can I just ask you before you go any further, will there be a transcript of today's hearing?
I have assumed so. That I see the parties haven't agreed a live note.
Yes, you haven't agreed a transcription, but obviously you can obtain a transcript. Is that
Yes,
what's
I'm sure the
proposed?
parties can obtain.
Just makes a slight difference, just how much we write down.
Indeed, well, I can certainly add that. Yes, we've ordered one.
Yes, thank you.
So, my lord, as you know, we say the judge reached the wrong conclusion. It isn't entirely clear whether that was an error, as it were, made at the outset while you want a principle, or whether it was an application of the principles. And the reason why we say that is because at various points, the judge expressly recognised the correct approach of looking at the whole award to identify the dispositive parts. But at others, he appeared to take the approach that the dispositive part could only be found in section 18, with the rest of the award comprising only narrative reasoning to the exclusion of orders. So I'll develop that as I go on. So for the construction issue, it's paragraph 17 to 32, which begins at core 5, page 93 that we're looking at. And the approach the judge took was to integrate observations about the legal approach in principle with the application of those principles to the facts. And so what I was going to do is go through those sections and essentially highlight where we agree, where we disagree. So if one starts, just sort of to give an overview, the section on construction is really divided into two parts. You have 17 to 24, and that is where the judge considers the overall approach required, which construes the terms of section 18, reaching the conclusion that section 18 was intended to be a comprehensive statement of the relief, and in effect says one need not read any further. And then 25 to 32 are the sections that consider paragraph 607 of the award, containing the endorsement requirement, asks whether there's anything there from which it's to be inferred that it should be an order, and concludes that there wasn't. So just if we go back to the judgment at paragraph 17, it's probably helpful for me to take your lordships through the judge's chain of reasoning and just say where we agree, where we disagree.
I'd say, obviously, you can and should do the exercise, but at the end of the day, on an issue of construction, this court is in as good a position as the judge to determine the proper construction. And though obviously you need to identify the judge was wrong, what ultimately matters was, did he reach the wrong construction?
Indeed, my lord. As you've seen from and I'm certainly going to be addressing you on what the right answer is.
Yes.
Perhaps what I'll do is I'll take this at a reasonable clip.
Yes. Well, we've read it obviously and studied it with great care.
I certainly appreciate that. If I may, I'll just take your lordships through that, and then
Yes.
it'll in a way it's helpful, my lord, to do so, if only to identify what we don't disagree with in the way the judge approached it, so as to highlight what we do disagree with. So 17 is the judge explains the conventional format of an award, and we don't disagree with any of that. Narrative section with factual findings, conclusions on the law, conclusions on the issues, and then a dispositive section. So we would simply highlight that in the case of the Spot CN award, that the sections that precede section 18 are not limited to narrative reasoning. They extend in their terms to the formulation of orders. The judge's approach at 18, if one looks at the first
Well,
six,
does it
yes,
extend to formulation of orders?
it does, my lord. Yes. I mean, perhaps it's useful to show your lordship that, and I'll take myself slightly out of my order and show your lordship that. So if we go, if we go to, forgive me. This is in the supplemental bundle.
Yeah.
And we go to page 322 within tab 14. So I'm going to take this in order, if I may. And whilst I go through this, I will explain how as one sees from the order, sees from the award, the endorsement requirements came to be made.
Well, do we perhaps start with the index? see what they've done. And the section you're now taking us to, 4594.
Is fifth from bottom on page 101,
Yeah.
indemnification in respect of other claims.
So basically, they've gone through res personae, facts, claims, defence, relief, and then section 14, tribunals, analysis.
Yes.
And then then there's interest, cost, conclusions, and then finally award.
Yes.
So the order you'd expect to see in the award.
Well, my lord, we of course accept that a conventional award is going to have a section at the end which seeks to set out dispositive parts. And we accept that if you were approaching an award afresh, you would come to it with the expectation that those dispositive parts are going to be set out in that last section. We accept that. But these are expectations. And what one has to do is look at the award as a whole in order to see whether or not those expectations are in fact met, or whether there are other orders that one finds elsewhere in the award that, because of the way in which they are expressed, are clearly dispositive parts. And so if one goes to the page 322,
Yeah.
We do highlight the heading. The heading is indemnification in respect of other claims. And so what one sees there is that in 594A, you have the reference to the cargoes that Taleveras entered into with Vitol. And then 596, you have what was known about the exposure by Taleveras to Vitol, and the tribunal has been informed there are claims of $135 billion. And I'm showing your lordship this in part because I want to explain to your lordships the background to how the endorsement requirement.
Mr. Phillips was a common arbitrator. Was he?
One of them was a common arbitrator. I'm afraid I can't remember which one it was.
Neville Phillips.
I think it was. Yes, you're right. You're right. And so one of the points that we made below was to do with why the endorsement requirement was made, as appears from the terms of the award. And that's not something that's addressed anywhere in the judgment, and is something that we repeat to your lordships, and I'll show your lordships this.
Yeah.
But if you look at paragraph 600 on 323, what you see is that there's an objection to the indemnity in principle by LNG, and they say that an unquantified and open-ended indemnity is an inappropriate remedy. And it says there's no evidence to support what it may be, etc. And then in 601, it draws attention to the MSA, the relevant agreement, which is that says that the tribunal is not entitled to make a partial award or an interim award. In other words, it can only make a final award. And then below that, NLNG's submission is that the indemnity would necessarily require the tribunal to issue a partial award and to reserve its jurisdiction indefinitely. But then it said that NLNG agreed that if the tribunal were minded to grant relief in the form of indemnification, it would have to be a final award. But it goes on to say that there's too much uncertainty in what those claims were, and the uncertainty over the page is scope of the claim, lack of clarity, open-ended nature of the indemnity. And then what you find in 602, the tribunal says that the language of the MSA in that respect is a little bit infelicitous, but in 603, the tribunal concludes that it may grant indemnification by way of a final award. And so pausing there, Taleveras notes correctly in their skeleton that neither party sought the endorsement requirement. That's right. Taleveras sought an indemnity without any qualifications around endorsement, and LNG, as you've seen, submitted that the uncertainties meant that no indemnity should be ordered at all. And the difficulty of the position that the tribunal was in was that it could only make a final award, but if it made a final award, then it had no continuing jurisdiction to see whether any damages that might be awarded in the VTOL award when it concluded were applicable to the indemnity. And that issue, the issue of not having an ability to police the indemnity, is what led to the imposition of the endorsement requirement, so as to give a degree of comfort to LNG, which of course was not a party to the VTOL arbitration, that when the damages were awarded, the VTOL tribunal would would endorse those damages as applicable to the indemnity. And the endorsement requirement was one that was not submitted by either party, but was a solution that the tribunal came up with of its own motion.
So you say that the intention was to ensure that any award would not be enforceable at all unless it was endorsed by the VTOL tribunal.
Indeed, and I'll show you Lordship 607, which is where that's said in terms.
But the terms of the endorsement in 605 are in terms of what is awarded.
Forgive me, Lord, I'm not following. Do you mean 607?
605,
Yes.
it says, determines that Taleveras is entitled to declaratory relief to the following effect. And then the indemnity is, by way of damages, indemnify in respect of those matters, including but not limited to any amounts awarded to VTOL in the arbitration.
Yes, my lord, but one has to look at the whole of 605, 606 and 607 to see and take a view about what was being ordered.
But
So
there's no doubt what was intended here by way of indemnity, which is that the indemnity was in relation to the amount awarded by damages in the arbitration.
my lord, yes.
So what scope is there for the endorsement?
Well, the scope is there could be circumstances in which damages were ordered or interest was ordered, where for one reason or another, the VTOL tribunal took the view that they were not applicable to the indemnity.
But how can that be? Because the indemnity is in relation to amounts awarded.
Well, my lord, to give one simple example, and I won't go to the underlying documents, but this was initially an issue below. The Spot CN award provides for interest, including interest on the indemnity. The VTOL award also provides for interest. Interest is within the indemnity. In principle, those two interest rates could continue coterminously at the same time, leading to double recovery. And so one of the issues that might arise in principle was that the VTOL award, when it came to order interest, might say this interest is the extent of the interest that we are awarding is not applicable to the indemnity to the extent that it's already covered by interest that is awarded in the Spot CN award.
I don't see any of that in 605 or 607.
No, my lord, because it is an issue which in fact arose. It was resolved before we made our submissions below, it doesn't matter that it's not something that is expressly referred to here. It is, all that matters, my lord, is that there was a concern that NLNG had raised.
Yeah.
That the problem in principle with an indemnity, coupled with the fact that the Spot CN Tribunal would have to give a final award, which is what it decided to do, was that NLNG would be exposed to an indemnity in respect of damages that were inherently still uncertain. And the only question is, did the Spot CN Tribunal make an order of its own motion that was seeking to deal with that? And so we say you can't stop at 605, you've got to look at 605 is terms of the indemnity, 606 is payment terms, and 607, of course, is what we rely on. The tribunal further orders that the terms of this indemnity be drawn forthwith to the attention of the tribunal seized of the Vitol and Glencore arbitrations. So that is found in the in section 18. And that any eventual enforcement of this indemnity be subject to, i.e. conditional upon, the endorsement of those tribunals as to its applicability in the context of any award, and in particular any consent award made in either of those proceedings. And that is partly reflected in section 18, but only partly, because there is the endorsement of the reasonableness of a consent award features in section 18, but that is clearly not the whole of what is being said here, because it is the endorsement of those tribunals as it's to applicability in the context of any award. And that is what is not included in section 18. Now, my lord, to sum it, and one can see, my lord, just to make good the point that this was not something that Taleveras had sought, could I ask you to go to page 90 of the supplemental bundle?
90.
90, yes, please. In fact, my lords, because this might involve holding a finger in the page whilst we look at another document, we did have further hard copies made. Could I hand further hard copies of 90 to your lordships?
Yes, please. Thank you.
So I hope your lordships have that. It may be worth just going to section 18 and doing a little bit of a compare and contrast, which is at page 329, tab 14. And so if one looks at compares and goes over to page 330, what the tribunal said in making its award was that it was going to adopt the Taleveras order subject to a few changes. And when one looks at this, there are a few minor changes. For example, there was an order sought in relation to Marcus, an entity called Marcus, which was not accepted by the tribunal. But the critical difference is if we look at paragraph 5 of the on page 330 and compare that to paragraph 3 of the draft order. If your lordships see the language that comes at the end of paragraph 3 of the draft order, first of all, you'll see that the language is very similar between the two, save that Taleveras had suggested at the end, if necessary, the tribunal is to expressly reserve its jurisdiction in this regards, or as regards the indemnity generally, in this order. And that was not something the tribunal was prepared to do because it was making only a final award. It wasn't reserving its jurisdiction. And what one does not find in the draft order is anything reflecting the endorsement requirement. And so one sees that the endorsement requirement, paragraph 607, is then something that is introduced by the tribunal in order to meet the bind that the tribunal was in with regard to policing the award.
I was some difficulty in understanding how does the Vitol Tribunal police anything? I mean, it's not within its remit. It's not. It won't be within its terms of reference or its jurisdiction, will it?
Well, the policing is not. There's no general provision that they should do so. The limit of it is that the Vitol Tribunal endorses the award that it makes as falling within the indemnity that the Spot-CM Tribunal has made.
How do they do that?
Well, if there's a reference by Taleveras and Vitol that requires them to determine that applicability, then they can do so.
So the Vitol Tribunal looks at the indemnity and sees that it says you shall pay anything that the Vitol Tribunal orders. What does the Vitol Tribunal then do by way of determining whether its award falls within the indemnity? Well, the indemnity says expressly that the Vitol award falls within the indemnity. What exercise does the Vitol Tribunal go through?
My lord, the Vitol Tribunal looks at the terms of the indemnity. So the indemnity is limited in certain ways. It's limited to certain cargoes. It's limited to certain arbitration proceedings. I've made the point about potential double recovery of interest. It looks, in general, at what it has awarded. It looks at the indemnity. I mean, you might have strange sort of outcomes where some form of punitive damages is awarded, which wouldn't be applicable to the indemnity. In a way, I do say it's not my burden to think of the examples. My only point is that there was a concern, and this was the way of dealing with the concern.
Well, the reason you have to address it is because, as I understand it, what is in the section which is headed "Better or Worse," decides and awards, paragraph 5. What there is provided for is that in relation to a consent order, i.e. where the Vitol Tribunal hasn't itself made a determination of the amount of an award, but it's consent, the Vitol Tribunal has to approve that settlement, i.e. between Taleveras and Vitol, as reasonable.
Yes.
Now, that is something which is within its remit.
I agree.
That makes entire sense.
Yes.
Is that when you're seeing whether or not an award is within the indemnity, it has to be approved as reasonable, because otherwise Vitol and Taleveras could stitch up your clients.
I would only qualify that in this way. The point about the reasonableness of the consent award really has nothing to do with the indemnity. It's just, is it reasonable in its own terms?
And that makes sense, because that's what Vitol's tribunal can say.
it does.
But what they can't say, it seems to me, sensibly, is whether or not its award falls within the indemnity, other than by
Well-
looking at the indemnity.
Well, if I may respectfully submit, my lord, that is the exercise that they do. They look at their own award, they look at the spot CN's award, and they endorse the applicability of their award to that indemnity. Now, your lordship may well say that your lordship has difficulty, as it were, identifying in what circumstances that endorsement would not be forthcoming. But what matters is that it is within the remit of the VTOL tribunal to conduct that assessment, and it is within their remit to give that endorsement. And if one looks back at 607, that is exactly what is further ordered.
Well, I think that's the point we need to look at, isn't it? And why you say that's an order. I mean, at the end of this case, there will be judgments from this court, and in the course of them, there may be paragraphs which would say, I would dismiss the appeal, or I would allow the appeal, or whatever. But that's not the order. That's the determination of the court, which will then be reflected in the order.
Well,
And what you have here, if I may just put the point to you, is you have a section which is described as the tribunal's analysis, starting section 14, and you have at page 324, accordingly the tribunal's determined is entitled to declaratory relief, and then the wording which you obviously rely on strongly, further orders in 607, but then at 329 we have award for the reasons set above, the tribunal hereby decides and awards. Now that's fairly clear cut, isn't it? What went before was the analysis and the reasons, viz. 329, why the tribunal decides and awards. It's difficult to understand what's uncertain about that.
Well, my lord, I'm detecting some resistance to my submission.
Really?
But if I may make a few points, just to try and persuade
Yes, of course.
your lordship. Of my
Just want you to understand what the points against you might be.
No, indeed, it's well understood, my lord, and put very clearly, if I may say. If one looks at 607,
Yes.
the language, first of all, the whole of this section that 607 comes at the end of, is concerned with relief. It is concerned with whether an indemnity, in the form of relief, should be ordered.
Well, so it's concerned with the tribunal's analysis of the entitlement to relief.
Indeed. And what if instead of saying the tribunal further orders, it said something like the parties should also do the following, or we think it would be sensible, or it's suggested, I wouldn't be here. It is the language of order that we rely on. Now, there's no question about the order that the indemnity be drawn forthwith to the VTOL tribunal. That's an order. It appears in the further section. There's no question that the requirement that there be an endorsement of the reasonableness of the consent award. Now, these are all, in my submission, clearly orders that are being made. That is unambiguous language. And it should be given effect to. Now, as to your lordship's point, that in this court, one may find in a judgment certain matters, sort of say, this is how I would decide it, so on. But what matters is the order. There is this difference between arbitration and court. In court, appeals are appeals of orders, not judgments. There is a clear formal distinction between a judgment and an order. Not so in the case of arbitration. What you have is an award and its dispositive, and within that award, its dispositive parts. And what that means is that, yes, of course, we accept that when there is a formal dispositive section at the end, one arrives with the expectation that it will contain all of the ruling. That is no more than an expectation, because there is no formal distinction. And one sees that, for example, from the French state case, where there was no dispositive at all. That did not mean that the tribunal had not ordered anything. It simply meant that one looked through the award for where those dispositive parts were.
No, but here there plainly is.
Sorry?
Here there plainly is a dispositive part.
Here there plainly is, but the point of principle is still there. And essentially, my lord, the other, just a couple more points, if I may. The question for your lordships are attempting to give this award a coherent meaning in a commercial and reasonable way. Now, we say there is a perfectly clear way of doing that gives effect not only to Section 18, but also to what appears in 607. And that is to say, Section 18 contains orders, and 607 contains an order. Now, there is nothing that requires a conclusion of incoherence in that. One is simply searching and giving effect to those parts that are orders. Contrast that with the approach that Taleveras has to take. Taleveras has to say that when the tribunal said further order in 607, it did not mean it. And therefore, Taleveras has to say, read down in some way the reference to further order as regards the endorsement requirement, so that one infers that although they said that, they didn't mean it. Maybe they meant this is advisory only or something like that.
Well, and we know that 607 makes reference to certain of the same matters that are in Section 18.
Yes.
And in particular, there's the reference to endorsement in relation to a consent award,
Yes.
but it's different.
Yes.
Now, it seems to me that, are you saying that there need to be both of those? There needs to be both an endorsement of the applicability of this indemnity and approval as reasonable? Are you saying they're cumulative, or are they?
Well, no. The approval of reasonable only arises where it's a consent award, and the applicability to the indemnity arises in a non-consent award.
But this 607 endorsement of applicability is in particular in relation to consent awards.
Forgive me, my lord, I may have, if I can, the aspect that one finds at 330 is not to do with applicability. The aspect that one finds is the reasonableness of the terms of the settlement. So your lordship's right.
So to both.
So
that needs to be two, the tribunal needs to do two things. It needs to endorse applicability, and in relation to consent orders, it also
endorses reasonableness. Yes.
Endorses reasonableness.
Correct.
So in other words, 607 is that aspect of 607 is entirely missing in Section 18. Yes.
And my lord, your lordship may say, well, is there a plausible reason why that may be so? And this is a point that Taleveras makes, that they say that we have to say that there's something has gone seriously wrong with the award, and we say we don't have to say any of those things. There is this difference between the endorsement requirement and what appears in Section 18. Everything else, everything that appears in section 18 was a claim for relief that had been made by Taleveras. And so it is plausible to understand what section 18 is doing is hereby deciding and awarding in relation to the claims that were before it by Taleveras. What marks out the endorsement requirement as different from that, as I was explaining, is that that was not something that either party had suggested should be any part of the relief. It was something that the Spot CN tribunal came to of its own accord. And so if your lordship's asking the question, well, why could this be? That provides an explanation.
Well, can I ask a question arising out of that? The proposition is that paragraph 607 is an order,
Yes.
restricts the enforceability of the award of the tribunal that is making that order.
Yes.
What's the source of the jurisdiction of the Spot CN tribunal to limit the jurisdiction of the arbitral tribunal, which is dealing with the claims, the Vitol tribunal? How's it limit? Because that seems to be the effect of what you're saying.
No model, because the enforcement is going to be of the indemnity. So the enforcement is the Spot CN, is of the indemnity under the Spot CN award. The subject matter of the indemnity is what is awarded by the Vitol tribunal. But that is, the endorsement requirement doesn't constrain anything to do with the Vitol award. What it imposes is a condition precedent to the enforceability of the indemnity by reference to the endorsement requirement.
But does that involve enlarging the jurisdiction of the Vitol tribunal?
Well, no, it doesn't involve enlarging the jurisdiction. Obviously, the fact of the endorsement requirement needs to be something that is placed before the Vitol tribunal for them to decide, but there's absolutely no reason why that shouldn't be the case. That is the reason why, when one finds the orders in section 18, the terms of the indemnity are required to be shown to the Vitol tribunal.
The enforcement of the indemnity, that would effectively be what, through the court?
Yes. But what the tribunal is, in my submission, doing is they're talking in terms of applicability, and so although it talks about the eventual enforcement, what they are in fact doing is imposing a condition precedent on the applicability of the indemnity.
What's the jurisdiction of the tribunal to impose a condition precedent on enforcement by the court?
Well, there's authority that establishes that you can have a conditional award. So you can have an award that says, in order for this award to apply, it has to be subject to a condition, and that's the Concola compliance case, which I think we had below but don't have here.
It's not the award that's conditional, is it? It's the enforcement.
Well, my lord, it talks about the eventual enforcement, but because it is in terms of the applicability of any award, it's actually talking about, it must be talking substantially about a prior stage, which is that there is a condition precedent that has to be satisfied before the indemnity applies.
I mean, not
So
much
these are-
of this makes a lot of sense to me, 607.
Well, my lord, in my submission, it does make sense, and to the extent that that there is doubt about it. I wouldn't say that that rebounds on my submission. What is clear is that
Well, it does, because I think Mr. Kitchener says, well, we rely upon paragraph 5 of the award. You say, oh no, that's not the operative thing here. There is a whole different ball game in 607, which should be read as an additional requirement for enforcement by the court.
Well, all I can say about this is essentially to repeat my submissions, which is that
You've got the material you've got.
Well, yes, this is what this is expressly talking about is applicability, and what it is expressly talking about is a further order. So plainly, the Spot-CN Tribunal considered that it had the jurisdiction to make an order that qualified by a condition precedent the applicability of the indemnity, and that is what we say they did. Now, if my learned friend wants to say that actually the tribunal in some way recognised that what it was doing in 607 was actually beyond its jurisdiction, and that's why they didn't include it, then that would be a further another point entirely. But I would urge your lordships not to conclude that in making this order, the tribunal in some way thought to itself, actually, we can't do this. What the tribunal plainly thought they were doing was making an order they had jurisdiction to make. And, my lord, the fact that this is not an order that it can make to the VTOL tribunal, because of course it can't order the VTOL tribunal to do anything. The most that it can do is impose a condition precedent. In other words, you can't enforce this unless the VTOL tribunal does this, leaving it to the parties, to Taleveras, to draw it to the VTOL tribunal's attention and make sure that that condition precedent is satisfied. And that is, sorry,
I interrupted.
and that is that provides a further distinction from other parts of the order that appears in section 18, because we are not talking about something that is ordered to the party that's going to be doing the endorsement, i.e. the VTOL tribunal. We're talking about something that is a condition that has to be fulfilled. And a third point, Lord, is that if one asks the question, why is the indemnity being ordered to be shown to the VTOL tribunal at all? Because that is part of section 18. And the only reason why one would be showing the indemnity to the VTOL tribunal is so that they can conduct the exercise of looking at their damages award and assessing whether the indemnity is applicable to it. Doesn't have to look at the indemnity in order to, for example, confirm that any settlement agreement is in reasonable terms. That's all within the confines of the VTOL arbitration. So the only reason why the indemnity should be shown to the VTOL tribunal is so that the endorsement requirement, either of consent or non-consent awards, may be fulfilled. And so the point that my learned friends make about the absence of the endorsement requirement from section 18 is actually a mixed point, because what is included in section 18, namely showing the indemnity, is only explicable on the basis that what is contained in 607 is in fact part of what the tribunal ordered. And so we return to the point that the choice, the construction choice that your lordships have to make is essentially being our construction says, well, section 18, you would expect it to be comprehensive, but it isn't. There's no getting around what 607 says in terms of a further order. we should be giving effect to dispositive parts wherever we find them, and we can do so without any incoherence in this award by giving effect to 607. And by the way, there are plausible reasons why the endorsement requirement does not appear in section 18. It isn't something that came from anything the parties were claiming. It's in a different category because it's a condition precedent, and it's the only way of explaining why the indemnity was ordered to be shown to the VTOL tribunal in the first place. So that might
I understand all that. Can I raise the question I was about? I can see how your argument works so far as the desirability of alerting the VTOL tribunal to the indemnity and the possibility that they may need to consider the extent to which their award falls within the scope of the indemnity. But is one possibility that the Spot CN tribunal was saying, well, it's not for us to determine how much of any award that the VTOL tribunal may make falls within the scope of the indemnity that we're ordering. That's not within our remit. But it may be up to, maybe something the VTOL tribunal can decide. But only going that far, using some perhaps not very clear language to achieve it.
well, that would be my point, and I'd go further and say it's not just not clear language. It just isn't there. So if for example what had been intended was that effectively an option could be given to the VTOL tribunal to put their hand up and say, yes, we've awarded some damages, but actually
they don't relate to those cargoes.
It doesn't relate to those cargoes, so it doesn't fall within the indemnity. That permissive language, that conceivably that could have been included in 607, but there is simply no permissive language there, and one gets that from further order and subject to. So, well, that is essentially where that's the most part of my submission in relation to construction. If I can, there are a couple of points in addition that I wish to make on that. But if I could first reverse a bit and just make my submission on legal principle. That is, so as you've seen from the judge's judgment, and I know your lordships are sort of in as good a position to consider it without critiquing the judge's judgment. What is absent from the judge's judgment is any reference to the principles that are set out in ZCCM, and we do urge those principles and guidelines as applicable and relevant to the exercise that you have to undertake. And one can get those from the French state case, which is at Authorities 24. Which is got to page 464. But I wanted to deal with start at page 470. And so this was there was a first partial award that had been rendered, and the French state argued that it was not an award that was capable of challenge. And Mr. Justice Butcher had to consider whether it was an award. If we then go to paragraph 18 on 472, the principles from Mrs. Justice Cockrell in ZCCM were there set out, and it says the courts have on a number of occasions had to consider the meaning and relevant indicia of an award and distinguish between procedural decisions on the one hand and awards on the other. We say that these are equally applicable to situations where one is distinguishing between procedural award and award, as they are to situations where one is construing an award to see what the dispositive parts are. Just to highlight a few of these, A, the court will certainly give real weight to the question of substance and not merely to form. So that's the emphasis on substance. D, going down to D, there is a role, however, for form. The arbitral tribunal's own description of the decision is relevant, although it may not be conclusive. E, it may be relevant to consider how a reasonable recipient would have viewed it. That's the objective approach. And then a reasonable, F, here's what a reasonable recipient is likely to consider. Description of the decision, formality of the language used, level of detail in which the tribunal has expressed its reasoning, and then G, what a reasonable recipient would consider, whether the decision complies with formal requirements, and the focus is on someone with all the information that would have been available to the parties and to the tribunal. So background or context is likely to be relevant. And so Taleveras says, well, none of that's applicable, but in our submission, it is. And it actually...
So which bits are not applicable, sorry?
Well, they say that none of this guidance is applicable because it's only to do with whether or not... they say it's only applicable if if the court is looking at whether or not something's a procedural decision or whether it's an award.
Yes.
And we say these are actually generally applicable to any situation in which you are construing an award in order to find its dispositive parts. And so what one is looking at is the substance, where substantively are the dispositive parts. And in a way, both sides emphasize questions of formality. But when one is looking at the formality of language is relevant, the precision with which it is expressed is relevant. And we say that leads one to the conclusion that 607 is a dispositive part. Now, one can contrast the way in which 607 is expressed with, for example, the Bank Mellat case. In Bank Mellat, the relevant wording that the court said was not part of the dispositive was wording that said the debtor should pay the sum in Switzerland, and that was the court said essentially, and there's a clear distinction between that sort of language of recommendation and the language that one sees in 607 further order. And I sense I'm repeating myself, but we do say, your lordships really have no choice. There is nothing here to allow one to reach the conclusion that further order means anything other than what those words ordinarily mean. And you are not driven to some conclusion, to any different conclusion by its absence from section 18, because it is additive to section 18 and is consistent with it. One of the additional points that I do wish to make, and to some extent it's a second order point, but it is still an important one, which is the role of the interpretation decision, and that was something that before the first hearing, both sides said the interpretation decision helped it. At the trial, I said it helped me, and Milan and Friend said it was neutral, as I recall. We say that it is of assistance to your lordships, and it is relevant. So it's at supplemental bundle tab 19. So the first point to make about this comes after the Spot CN award was rendered on the 30th of January 2023. And what happened was that there had been a partial award in the VTOL arbitration back in 2021. And so Taleveras, in the sum of $31 million. And so Taleveras demanded payment pursuant to the indemnity of that partial award. And Taleveras said that the indemnity didn't apply to a partial award, and sought an interpretation that it only applied to final awards. And that was what the Spot CN Tribunal decided. It said it only applied to final awards. If one goes to 354, you'll see that there was a request, a response, and then a reply. And then if one goes straight to page 6, just to see how the tribunal decided it. I don't need to go through the reasons that the tribunal gave in detail. The bit that is significant is in Roman 10, page 358. You see that in the opinion of the tribunal, the terms of paragraph 605, 606 and 607 and the terms of section 18, 2 to 6 inclusive of the final award are both clear and clearly intended to refer to any final determination. And then if one looks at sorry, forgive me, I'm just pausing. This interpretation decision is part of the final award. And so when one is when one is looking at what the final award means, this is part of the materials that one is looking at. And what is significant is that what it shows is that the tribunal was by no means saying our award is in section 18. The tribunal is looking in construing what it has ordered at section 18, but also looking at 605, 606 and 607. And that is, so we do say that when you are approaching the award in a commercial and reasonable way, one should have regard to a reasonable recipient would be considering how the tribunal expressed themselves in seeing where the relief, where the orders were contained. And this shows clearly that they were not by any means restricting themselves to section 18. There is if you like, a third order point, my lords, which is that one of the points that NLNG made in relation to the interpretation decision by way of an alternative case in its reply submissions was that the partial award could not be subject to the indemnity in any event because there had been no endorsement requirement fulfilled in relation to that, in relation to the interim award. Now, I can't rely on anything the tribunal said because they didn't deal with that alternative case because they didn't need to, because they accepted NLNG's primary position. But it is nonetheless of some relevance that knowing that that was what our case was, our interpretation of the Spot CN award, and knowing that this was a live issue because there would soon be a VTOL final award forthcoming, and expressly referring to 607, they did not say anything to question whether or not the whole of 607 was part of their order. They did not, for example, My lord, that's, I see your lordship's reaction. That's why I describe it as a third order point. But it's a point that it's something to be borne in mind. The primary point that we make, which I described as a second order point on the interpretation decision, is look how the tribunal viewed the provisions of their own award.
Or what might have been helpful if you'd actually asked the tribunal to interpret 607.
Well, my lord, neither party sought an interpretation in relation to 607. In fairness to my clients, they're the ones who got closest to it by making this alternative case in the interpretation decision. But of course, our position is it's clear, because 607 is clear, it says further order, it means further order. My lord, there are a few further points that I should probably address. The judge concluded that the endorsement requirement lacked utility. That is in paragraphs 28 to 31. And he concluded that a dispute over the indemnity could be resolved by a fresh action between LNG and Taleveras. Your lordships have my submissions as to why that is wrong. It did in fact have utility. At the very least, it was something that the tribunal clearly considered had utility, because it was their way of resolving the bind that they were in, having to make a final award. And neither party has suggested, it's common ground, that the dispute over the indemnity would not be resolved by a fresh action, as the judge found. That was not something that either party had submitted to his lordship, or as I understand it does today. And it's actually difficult to see how it could be. It wouldn't be a dispute arising from the agreement, it would be a dispute arising from an award, which we say in any event would not fall within the scope of the arbitration agreement. At the very least, it would be an extremely time-consuming and inelegant
Well, I haven't
way.
seen the arbitration clause, but they're normally very widely worded.
Yes, it refers to disputes arising from in relation to the agreement. I haven't got the precise language. I'll, if you give me a moment, I'll find it. But at any rate, the primary point that I make, my lord, is that wasn't something that had been suggested on either side to the trial judge, and in any event, it has utility.
Can you somewhat identify the arbitration clause? It may be in the award.
Yes, I'm just looking, my lord. If you bear with me one second. It is.
It's on page 19.
Yeah, if you go to paragraph 10 of the Spot CN Award, page 117, tab supplemental bundle 14, page 117, and what clause 16 of the MSA says in its material parts is any dispute, controversy, or claim arising out of or relating to this agreement.
Or wouldn't it proposed, wouldn't the judge say that the dispute would be arising out of or relating to the agreement?
We would respectfully say that it's not obvious that it would be, but at any rate, neither party is suggesting it. My lords, unless your lordships have anything to ask me about on the construction issue.
No, we don't. Same. Before you go on to the jurisdiction question, we're just going to rise to consider where we go from here.
Problem is, you're not going to get your turn.
Yeah, yeah. Sorry, what was that?
Oh, yes, that was the embargo.
Oh, well, that's not going to rise.
Which is that?
That's not right. It's all going, yeah.
But is it not?
Oh, the
in
embargo.
draft? Embargo. We want to see it before it. In case we have further discussion about it.
Yeah.
And I have to smile.
Yes, exactly. That point.
Awkwardly.
Yeah, that's not essential, but standing up and clarifying the position.
Oh, yeah. No, I do need that. I should
You probably should. Should make clear.
And so,
I don't think so. And then
must be.
Yes, yes.
I told him to stay
Cool.
tuned.
It's one or the it's just common. I think that's obviously what. Yeah, that's and yeah. That's what
what rise of able?
Yes, thank you. We had decided that we will not need to hear Mr. Kitchener on the issue of interpretation construction, and that therefore means that the appeal will be dismissed, and we do not need to therefore to determine the second issue on jurisdiction. So we don't need to hear from the parties on that. So that concludes the appeal. We will reserve our judgments, and they will be provided to you in the usual way in draft and subject to the usual embargo with which you must comply. I think you've provided us with email addresses to send to. That's done for a reason. If there are other addresses, very often we get late requests for further names to be added at the last minute. If there are further names you anticipate will need to see it, then please deal with it now.
Well, could I just raise one issue directly in relation to that? First of all, Mr. Gardner, who's behind me, actually represents Vitol,
Yes.
not Taleveras. Vitol have been involved throughout. You can imagine what
Yes.
their interest is. Could I make a preemptive request for Vitol or Vitol's solicitors and counsel to be added to the list of people permitted to see the draft
Why
judgment?
do they need to, or should they see the draft?
Well, my lord, they were made privy to the judgment at first instance, and that did prove useful because it became their involvement, their input was relevant to the order that was made. I think that's considerably less likely in relation to the disposal of the appeal because the order should be pretty
What I'm
straightforward.
minded to do is not to deal with that, but if when you see the draft, if you
Yeah.
think it needs to be sent to them, then you can at that point request it.
Happy to.
But they're
do
not
that.
parties to the proceedings
not.
or to the appeal,
They're not.
and I'm not sure why we would do it.
They have actually been the recipient of the cash, subject to undertakings.
Well, that
given
may
by
well
them.
be.
I'm happy to deal with it in that way, my lord.
Yes, very well, thank you. When you have the draft, if you can let us have the usual list of corrections, pointing out typographical errors, etc., not to re-argue anything, and also if you can let us have any agree an order if you can. If there's anything you can't agree, if you can let us have written submissions.
Yeah, I do have copies of the unanonymised judgment if you'd like a copy.
If you yes, please. If you just perhaps after the
Yeah, of
hearing, you
course.
could hand that.
Yeah, sure.
But otherwise, that concludes matters. Thank you very much.